We do have someone wants to come on up. We still have another chair here. There might be one in there, although I think that's for Kevin's setting. We might be checking to see if we can grab a few more chairs too, so hope folks don't have to stand for sit back there. I first want to take this opportunity to thank the speakers that have agreed voluntarily to present today. And when they come up, I'll introduce them quickly before each of the sessions. So you know these folks, but for those who aren't as familiar with them, I want to certainly give them proper introductions. So I'll do that as we get into each of those 5 presentations that follow this morning. The purpose of this forum, we started this State Engineer Forum, I think about 2004, in an effort to help educate and inform the water users, the public, what we're dealing with, some contemporary issues at the State Engineer's Office, Division 1 Resources. The last time we had one, probably up in this area here, Thornton or this building, was probably mid-2000s or 2008, something like that. And then we started to take the forum on the road, if you will, because people wanted to participate in this on the West Slope. So we started combining this with our fall forum, the Water Officials Association fall forum, and started going around to the different basins around the state. And that's been very successful as well. But we felt like it was time again to bring it back to the Denver area and we have just a standalone State Engineer Forum. That's what this is. So you'll see from the topics that are on here, there's some of the contemporary issues that we're dealing with. And we're seeking some input from all of you on. We're doing this as just various outreach efforts. We've had a number of outreach efforts over the past year or two. In regards to this first item that I'm going to talk about in the State Engineer, Division Engineers participation in water court cases. We started probably about 2 years ago. We heard a lot from various folks about the State Engineer's role in water court cases, State Division Engineer's role, particularly in some cases that were involving in the Clear Creek Basin. And so we heard loud and clear about those concerns. We started talking a lot internally with our leadership team about what our role currently is in the water court process and kind of just did a lot of introspection over the last year or two to find out what our role should be going forward in the future. And we recognize as institutions, you know, we've got to adapt and change as well as needed because of just the environment we live in. As you know, we're an administrative agent. We're here to execute the law, and most of what we do and what our direction that we have for our participation in water court cases is driven by the legislature. We're also guided by the water court rules and to some extent decisions of the court on what our role is in that process. So we've done a lot of outreach over the past year. We really kicked this off in earnest about a year ago with our State Engineers Annual Meeting, which is an internal meeting that I conduct in Denver in late April of our senior leadership team, even though all of our staff's willing to participate. So we talked about a number of things, and this is one of the things that we kickstarted in earnest last April and was getting a lot of input from our staff on how we would proceed given the concerns that were raised on our participation. So we know that that's a challenge. You know, if we're going to redesign or rethink how we're going to engage, we've got to do that via the stakeholders that are out there. So over this last year, we've had a number of outreach efforts. We've participated in some outreach to the bars in Glenwood Springs here recently, and one here in the Denver metro area. We did some discussion of this at the Colorado Water Congress, and we may have been there as well. And so this was another opportunity for us. We wanted to have this, and again, some feedback before we got into our annual meeting coming up this April. So I wanted to, since we wanted to do this outreach, we thought, well, just instead of having just a forum on one topic, we probably would join that with some of the other topics that you see here. And so we do appreciate all of your interest in attendance today. It's great to see this good turnout. So when we just do this discussion, what I'd like to do today, in all of our prior presentations, it's been mainly us standing up here trying to present and get raise just a lot of questions. What I'd like to hopefully do this morning during my presentation here is to engage you in a little bit more direct way and try to get some input from you. I've got a series of about 12 or 15 questions I'd like to step through, and I'd really appreciate trying to engage in you and how we'd like to do this. I've got kind of 5 general areas that I want to cover that really kind of capture in a general way areas that we're thinking about in our role with water courts and water court cases. So I'm going to start out with a few questions and some general questions regarding our role as an advisor to the court in the consultation process, and then just in basic water administration. And then there's an area I want to focus on, a few questions as it relates to injury to water rights, and then some issues of law that come up as part of that process. And then lastly, talk about engineering and scientific roles in that process. First, I'd just like to, I recognize a lot of folks here today, but just as a general show of hands, are people, how many people are generally familiar with the state engineer's role as far as the consultation and what our general role is in the water court process? Can I just get a general show of hands? Looks like most of you are generally very familiar with that. That's good, because I think as I ask these questions, I won't have to maybe go into a lot of description about like the consultation process, even though you're maybe not directly involved with it. Many of you are familiar with that, and so that's helpful. So I'm not trying to get you to raise your hands in the sense to attribute anything to you or that you're representing your clients or anything like that if you're here on that behalf. I'd like to have you put on your cap a little bit in the role of maybe as a legislator. Think about how you would respond to these questions. If you're going to give guidance to the Division of Water Resources from the standpoint of representing the water users as a whole out there. And so that's what I want you to kind of think about. This will help us. What I want to do, and as I ask you these questions and get just a general show of hands as we go through this, give us some guidance a little bit as we kind of formulate into our discussion in April. And so this will be really informative for us. So as we go through it, there'll be an opportunity as we do that to elicit some comments too. If some of you have some comments you'd like to share on a particular question, please raise your hand. We'd like to take some input from you. I know I've gotten some input already this morning from a couple of you. So, so first I want to get into a couple of general questions about our role in the summary of consultation process. So first I want to ask this question, just to show of hands. Should the summary of consultation process that we do with the water referee, our division engineers working with the water referee, and so thinking about just that summary of consultation process, should it be fully exhausted before the engineers seek to become formal parties to a case? So just a general show of hands, what do people feel? Do they agree with that statement that we should fully exhaust our summary of consultation process before we even decide whether we're going to file a formal statement of opposition or a motion to intervene? Can I get just a general show of what people feel? Okay, that's good. So let me carry on with the secondary question. I think that ties to that. So given that, would you prefer that the engineers just file statements of opposition when we think the consultation process will not resolve our concerns? So you think we should just immediately, like anybody else who wants to file a statement of opposition, should the state division engineers just get into those cases? That anybody have a strong feeling about whether we should just immediately get into that?
No.
So you maybe weigh in more on the first one. Do you think we should get more of exhaust our summary of consultation process before intervening into a case? Maybe we'll get Tom. Yes.
Starting to these questions about that would be consistent. And so I'd like to suggest that in context of those questions, what are the priorities to show that you're playing factor?
Okay.
Could you repeat that?
Yeah, let me see if I can capture the comment. Both of those are online and just from the audience here too. About, I think you were characterizing too that it's kind of hard to put these questions in context, not knowing what our resources are and what our priorities are in getting into these cases. Certainly, the questions I'm going to go through today aren't really trying to elicit necessarily, unless folks want to weigh in on this, of why we get into cases. But I think those of you who are familiar with the process, I think we've had forums on this in the past here where we articulated what areas in these or reasons we get into cases, what things we're looking for. I know that's been some time ago since we've done that. But we have some clear areas where things we're looking for. And I'll get into this a little bit. As you saw some of the general areas talking about, when we're talking about administrative aspects. And so we'll focus on that, a few questions there. and maybe we can come back to this a little bit, because obviously I know what I'm going to ask as far as these questions, and you're just hearing them for the first time. But I'm trying to create a little bit of dialogue here on that process. But let me go ahead and maybe just blend a couple of the next questions here. We obviously know we've got some simple cases out there, and then there's some more complicated cases like changes of water rights, plans for augmentation. Should the division engineer's consultation with the referee occur after a submittal of a proposed decree engineering report? This has been raised a lot in our in the water court committee as well. But oftentimes we as a state may be getting into some of these cases, and maybe you do on behalf of your clients too, if you don't have the engineering report there, you don't have all the information in front of you. And that sometimes will trigger, again, about our priorities and our resources when we get into cases. And I've got a few questions later on too, talking about some of these things, maybe at degrees of matter of, if we're talking about matters of injury to water rights, when we get into those, depending on the magnitude of the injury that's there. So I guess, any thoughts from folks about in terms of that process and the consultation, do you think it's important to have that proposed decree and engineering report, not only for the state division engineers, but for you? If anybody want to weigh in, have comments on that? Yes. Yes. So the suggestion that was made, if I characterize it right, that we should have some kind of pre-consultation that's submitted with identifying issues. And I guess in doing that, ahead of maybe when the formal consultation is used, is that what you're suggesting? And is it then hopes that it would identify issues out there that people could engage with the state division engineers, or just to make other water users aware of them, to make them aware of whether they would want to engage in the process? I'm just trying to vet this a little bit more to find out what you're suggesting there, what that would lead to. Okay. Other, yes.
I don't know how much people would rely on what I like to see is the state engineer do it. If it's a small case, you know, like a money with well and stuff like that, I can see you just taking like just turning the balls on all my clients that have to do that. But in the bigger cases, when there's, you know, several hundred feet of water, one feet of water, I understand the opposition, and they just set back and walk. And there's that, because always on your house on the road, there's probably a study out there that's got work process, and you hit a lot and do look like you go in so I'm saying basically, get Bob, who will always take care of it for us, but the big one just step back and let the people make the water.
Okay, the suggestion that was made is he was suggesting that the state division engineers can get into the smaller cases we're dealing with small quantities of water. I guess I assume you're talking about changes of water rights where there's involved, and actively try to be engaged in that process to protect those smaller users, I guess, that are out there. But when there's the big changes of water rights involving large amounts of water, final statement of opposition, but kind of sit more on the sidelines if I'm getting your statement. Others have thoughts about Paul?
I just have time, and you could also be finding that if they're no, I think sometimes in these bigger things, the things involved, maybe contacting the city and the I don't know. Otherwise,
to feed on that question for the folks online too, and as part of one of my next questions about the consultation process, and it gets at some of the feedback we've got now about whether if we just file a statement or a consultation that we do with the water authority and identify all the issues out there, and whether it's a simple or complicated case, and then just let the court take its process, let the water users or others who want to participate in that as other parties just carry that forward. And we would remain essentially as an advisor to the court in that consultation process and not be a participant as an opposer in that. I'm curious of what others' thoughts are and any comments on that. Yes. So,
we might think about ourselves trying to run your office as the role in representing water users as a whole. Could you tell us a little more about what you actually see the role of the state engineer and the engineer generally? Overall, what's your job like?
Well, we probably don't have enough time to take that. Question was asking what our role is as a state division engineers. I think in water court cases, maybe at a higher level. Certainly, this is something we've had a lot of discussion about and why we're here and trying to identify what our role is in this process. We do believe, we think it's very clear in the statutes that the legislature has given us this ability to be an advisor to the court through this consultation process. And I think the case law that's been out there has opined on this a number of ways about what the role is. Now, I know some may dispute to what level we are in that process or that role as an advisor to the court. Some don't like that kind of direct communication and almost feeling like we're having these ex parte communications with the court outside of the broad realm of all the other people who might participate in the case. So I think that's very clear, and we think we have a clear role in that as it relates to compact issues. When there's compacts implicated, we certainly feel that we have a very direct role working with our Attorney General's office and our interstate unit in protecting those interests of the state, because it's not the water users directly who are taking that role. It's the state who has to pick up that role. So we think that's very clear. I think where we had a very active role historically, prior to 69 Act, the state engineer never really got in cases. I mean, the water users out there basically police themselves. If they wanted to get in a case to close it. But certainly after 69 Act and the creation of the water courts, a lot of things were more defined in the water court rules and the statutes. We, over time, started playing a bigger role as far as evaluation of injury in cases. And I think a lot of that has stemmed out of our active role as an administrative agent in our substitute water supply plan process that we have, and our evaluation of water permits, where we are the agent that administers those, acts on those, and adjudicates those. That's not a role of the water court. And so in that process of doing those evaluations, we certainly have a lot of expertise and knowledge about evaluation of injury, because we have to do that. These things are oftentimes very similar to plans for augmentation or other changes to water rights, and we're doing these temporary approvals of it. So we've seen our role evolve over time, and I think it came out in one of our last discussions about this at the COE last October. I think Paul may have pointed this out. Maybe in that process, in that active role we play in the substitute supply plan review process, maybe some of that role is kind of blended over into the water court process more actively than some would like. And that's kind of why we're trying to get some feedback and the input from users to find out what is that role? How engaged should the state division engineers be in that process for like injury determinations? And I've got some questions here in that regard. So maybe just to get on that point a little bit more, Cindy, and devote some of these questions and input. When people generally agree that it's a role of the state division engineer, since we're the administrative agent, once the court enters a decree, we're the agent that administers those. We obviously got to work with the water users in that process, but we've got the state or the division engineers, the water commissioners are out there administering these decrees on a daily basis. So if would folks generally agree that engineers, when we identify administrative issues in the court for the court and our somebody's consultation, do you think that's a proper role of the state division engineers? I would think, we've generally heard since people think that's a proper role for us. I think, and even when we file statements of opposition, if it's specific because those administrative issues aren't being addressed, I think we've generally gotten a feedback that people have generally thought that was a proper role for us. I don't know if anybody strongly objects to that, us playing that role. And I think one of the other things that we get into, one of the areas of big questions is this injury to water rights. Whose role is it in that? You know, is the state have some kind of role, as Ivan suggested, to represent water users out there? I'll use that generally. Some would suggest, you know, big users can defend themselves. Maybe the state has some role to play in protecting the smaller users who don't have the resources to hire engineers and consultants to do them cases. But I think maybe just to get some discussion going a little bit about that role in our consultation process. If in the consultation we identify potential injury that may occur there, do you think that's a proper role for us to take in that consultation process? And I'm not talking about the next kind of second question, that'd be whether we get engaged in that in an objective way, objecting to the case. But I'm curious what folks' thoughts are about that injury determination and what our role specifically should be in the consultation process by itself. Any input on that, Steve?
I just think that there are very few people that understand the complexity of
So, Steve, to your point, question, if I captured it, was you seem to be more indicating our role is very important as far as those administrative issues. But specific to, is those changes of otherwise come through, or particularly if we're dealing with documentation plans, and there's an evaluation of injury in there. What do you believe the role of the state division engineer should be in the consultation process? Do you think we just identify that there may be injury there? And again, this gets back to a little bit of one of my earlier questions about oftentimes you may not be able to make that full assessment if you don't have an engineering report or proposed decree to look at. We may know from past experience on if there's been prior changes on those shares, for example, and if they're trying to ask for more per share than the prior ones. Maybe there's some of that going on. But oftentimes we're looking at, you know, return flows, maybe some return flows, quantification of historic consumptive use. I'm just curious whether you or others want to maybe just provide any comments on that, and whether one should be identifying those in the consultation process. And then secondly, I just maybe to tie on to that, should we take some kind of more active role and get into a case and oppose it? And maybe I'll add to this, would that not matter what the size and the amount of water is involved, or should we get involved only when there's a large amount? I know that's always, you know, what do you define by large or blanket injury, but so I'll throw that out there and see if I can get some input on that.